Okay, great. We're going to call to order our first hearing of the evening, and this is on the application of Michael Mangum. The application is dated March 19th, 2014, and Mr. Mangum is seeking a variance from the terms of Section 61 of the zoning bylaw. He seeks to build a two-story addition to the right rear of his existing single-family residence with a 4-foot by 16-foot covered porch. The property is located at 188 Brook Road in Milton, which is in a Residence C district. The addition is proposed to be set back 27.9 inches from the rear property line rather than the 30 feet which are required by Section 61 of the bylaw. My name is John Leonard. I'll be presiding at this particular hearing. With me this evening, to my immediate left is Board Member Frank O'Brien, and to my immediate right is Board Member Ted Daber. We'll have the usual rules for this particular hearing. We'll hear from the applicants, and then we'll hear from any person present who has questions of the applicant. We'll hear from people present who wish to speak in support of the application, and people present who wish to speak in opposition to this particular application, if any. The proceedings are being tape recorded this evening. The room is rather large, though a lot of people are not present, but they will be coming, I can assure you of that. So we'd ask that before you speak, speak up nice and clear and loud. Tell us your name and address before you speak, so we'll have a record of the proceeding if we have to revert to the tape recording.
Is it okay to approach the board?
Oh, of course. Yeah. Make yourself comfortable. I'll summarize the advertisement for the sake of the record. We'll also have the application, which is dated the 13th of March, 2014, as evidence at this particular hearing. We have a denial letter from Joseph Prondak, our building commissioner, that's dated March 3rd, 2014. It's not unusual that the denial letter comes in before the application is dated, but that's because they've spoken to the building inspector beforehand. So we'll have Mr. Prondak's letter as evidence. We have a plot plan that the applicants have filed. It's by Hoyt Land Surveying. It's dated January 28th, 2014, and it shows the subject property on Brook Road and the dimensional requirements for the position of the housing. You just have to wave your hand there, sir, and that'll keep the lights on. Thank you very much. There you go. That'll happen frequently until the room fills up. And it shows the porch and the proposed addition. So we'll have that as evidence at the hearing. We also have a page of sketches from Design for Mangum Residence. Okay, it's pencil and it's difficult to read. And it's by H.P.T. Thomas from Natick, Massachusetts. And it shows the preliminary designs for the proposed addition on plans that they may be dated, but actually I don't find a date on them. But we'll certainly we'll take those as evidence at the hearing as well. The applicants have also filed with us several petitions. Well, I guess it's one petition. I'll read the petition and indicate who signed the petition. The petition is dated April 14th, 2014, and it's to the Board of Appeals from the Mangums. And it reads, below are signatures of abutters to our property at 188 Brook Road who have reviewed our plans and are in support of our obtaining a variance from the town of Milton to proceed with the construction. And we have signatures from David Allen at 192-194 Brook Road in Milton, Laura Carew at 52 Hawthorne Road, David House at 54 Briarbrook Road, and it looks like Mary Ann, I'm going to say it's Dolben. Is it Dolben?
Dolbear.
Dolbear, it could be. 48 Hawthorne Road. So we thank the neighbors for participating and sending us these plans. So without further ado, welcome to the Board of Appeals. Why don't you tell us about your application and why the board should allow this this variance?
Okay. You want to take that one for you? You want me to do? You can, if you want.
Okay. My name is Stacy O'Levi. I work for Home Projects Inc., Sperling Thomas.
Okay, before you go further, Stacy, would you just tell us how to spell your last name?
Oliva.
Oliva. Good, and you work for?
The design firm that designed the addition for the
Okay.
Manghams.
Good. Welcome to the Board of Appeals.
Thank you, thank you. Basically, what we tried to do here, you can see that the shape of the Manghams lot is kind of awkward. We're dealing with sort of a five-sided little frontage scenario. And to make the Mangham space work on the interior, we were looking to expand the kitchen space at the first floor level, but make the 4 bedrooms on the second floor level work for them. And the only real way we could do that was by going off the rear of the home because of the side yard setbacks being at 10 feet, no real space to go left or right because of the driveway to the right side of the home. We had no choice but to go to the rear. So in an effort to minimize the impact at the first floor level, we included the covered porch. So you're not completely destroying the backyard space and that sort of thing, and then cantilevering the second floor over the porch area to make best use of space that way. And it's really just a minimal corner, as you can see from the plot plan, that needs the relief from that standpoint.
All righty. And is the exterior construction of the facade going to be consistent with the existing house?
Very much so.
You submitted the petition here. Are any of the people on this petition the direct abutters, either on the left or the right of your property?
Yes.
Okay, who's the abutter to the left?
The abutter to the left is David House.
Okay. And who's the abutter to the right?
The abutter to the right is David Allen.
And how about to the rear?
To the rear, the Carews are to the left rear.
Okay, yes,
and
they are.
Marianne Dolbear is to the center.
Okay.
And then we were unable to speak to the other abutter in that corner.
Okay, you tried to contact the
We
Nardozis,
did, we
you?
went by there and she didn't, she was busy at the time, so,
Okay, so she was unavailable.
yes.
Let me see if my colleagues have any questions. Do you have anything else you'd like to add in support of your application?
No, not at this time.
Okay, Mr. O'Brien, do you have any questions of the applicant?
So this is, just run me through what the addition is, what the additional construction is. So we're talking about,
We're on the first floor level, we're bumping out the kitchen.
okay,
And that is the family's main access into the house, so they'll be coming up you can see on the pictures that I had given to you guys this evening, they have a back entrance currently that they use on a daily basis. So we'll be shifting that back entrance back a little bit more, and they'll access that via the porch. And then on the second floor, they currently have 3 fairly decent-sized bedrooms on the second floor, and then a 4th very small walk-in closet scale size room that we're going to use as an access point to the new master bedroom, which will be part of the second floor addition, along with a master bath.
okay, you said something about cantilevering.
When I said cantilever, it just goes over the 4-foot porch below.
I mean, the second floor
The
extends
second
over.
floor goes over the porch below.
Entirely?
Yes, the 4 feet by 16 feet. So the full depth of the addition off the rear of the home is 12 feet by 16 feet.
Any plans to enclose that?
The porch?
Yep.
It's really, the house is very nicely detailed. It has a lot of corbelling and crown moldings, and we're really looking to carry that all around. So the back is just it's gorgeous as it is now, and we want to enhance that and not deter from that.
Okay, but just to be clear in my own mind, the second story addition will come totally over the first floor porch.
Yes,
Thank you.
sure.
Thank you, Mr. Chairman.
Mr. David, please.
I apologize if I'm going over territory that was already covered, but, and the exterior of the addition will be clapboard as the
Yes,
house is?
it's going to be, we're shingling a portion of the first floor, but in an effort to save some costs, we're going to be using clapboards on the upper sections, just from a labor perspective and a material cost perspective.
Okay. I think that's all I have.
I just have one more question. I know these are not construction,
No, it goes over the full porch.
I'm sorry.
I'm sorry.
You all right? Do
Yes,
okay
yes.
what the testimony is given?
Yes, absolutely.
Okay. You've submitted some conceptual plans here. They're called preliminary plans.
Correct, but that would be, we've been basing our construction drawings on those. That was what we had taken the drawings to the level when I went to see Joe and Jay to get the letter of denial.
So my question to you is, can I assume that your improvement, if you get your variance, is going to be constructed in substantial conformity with these plans?
Based on those, yes.
These preliminary plans, and we won't
Exactly.
find a deviation between the final plans and these plans?
No, sir.
Okay, that's, pardon me? Yeah, but Mr. O'Brien has the clarification. Go ahead, sir.
I just want to double check that, okay? And the reason why I'm asking is because, again, based upon what you said, this plan shows the second story going completely over the porch, while the plot plan appears not to show the second story going completely over the porch. What am I to go by?
The second floor goes completely over the porch. I think when the engineer drew this, we looked at it as the second floor was going completely over the porch. So
Okay, I
he
just
just
don't
didn't
wanna
make an
be-
extra distinction. The
Okay.
second floor is entirely going over the porch.
She has labeled it as being a porch, but it should be shaded as the full addition, basically, with a
Or with,
porch under.
or with an extra note to say second floor
Right.
at this point.
And that's what I was clarifying with her while you guys were discussing it.
And again, this is not an enclosed porch. We're not talking
An
about
enclosed
double hung
porch.
windows and making it into
It's-
an extra room. This is an open porch.
Columned open porch. Again, it's a theory where the backyard is very tight at that area, so we're trying to maintain as much depth of field as possible.
Okay. The reason why I'm sticking on this is because people expect to get what they see. And if you have a situation where halfway through the construction, you decide all of a sudden this would make a nice, fully enclosed, three-season porch that isn't gonna match the variance that you've been going for, and that will be a problem.
It's not deep enough to really close it in.
It's only 4 feet deep.
It's only 4 feet. So it's a rain guard, basically what we're talking about. When you step up, you're just covering yourself from getting out of the rain.
And for a couple chairs and just kind of spilling out onto the patio area and the
If
lawn
you close it
area.
in, you'd be like a refrigerator, basically.
I just,
But it's understood how you're saying it, yes.
thank you, Mr. Chairman.
Okay. Mr. Deba, any more questions?
No more questions.
Okay, let's see if there's anybody who wishes to be heard regarding your application. Is there anybody present this evening who wish to speak in support of the Mangum's application for variance? And so the record indicates there's no such person present. Let me ask the more ominous question. Is there anyone present this evening who wishes to speak in opposition to the Mangum's application for variance? And there's thundering silence out there. So unless you have something further to add, we'll call the evidence portion of this case over. Yes, Mr. Davis,
Sorry.
please.
Did we get this gentleman's name on the left? If we did,
I
should that be-
apologize.
You know,
That's
you're
okay,
absolutely right, we
I
did
did
we
speak
did
and
not.
I didn't,
Oh,
I
that's,
let the board know who.
that-
I am Paul
terrible.
Sperling, I am president of Sperling Thomas. And we've been in front of your board many a times.
Have you enjoyed your
We
appearances?
love it. We think Milton is the best board.
And we forgive you for not telling us your name. So we'll end the evidence of
I
the,
think the camera would have recognized me. No.
well, actually, you did look familiar, but we have a lot of architects and builders and designers here, and so it's, so, as you probably know, under the open meeting law, we're obliged to consider your application in open session and to vote on it, and we intend to do that here and now. So, Mr. David, do you want to be heard first?
Yes, I think it was a very good presentation, and the addition looks like it'll be an enhancement to the house. Significantly, all of the abutters except one has expressed that they're in favor of it, and my understanding from what you said, that you didn't speak with the fifth one, is that they didn't express any opinion one way or the other. Is that
She did not express an opinion one way or the other.
Okay, and with the, I guess, 2 feet, 3-inch difference, I consider the variance to be de minimis, and I would be in favor of it.
Mr. O'Brien, please.
Thank you, Mr. Chairman. Me too, I'm in favor of this. I think it's behind, pretty much almost totally behind the existing structure. I would just caution the applicants and the builder about the 27.9. It's easy to lose sight of the 27.9 when you've got second floor addition, so you gotta make sure that your dimensions are correct, but I'm sure that your builder will do a good job, and our building department will be on top of it as well. With that, I'd be voting in favor, Mr. Chairman.
Well, I thought the application was very well presented. I like the plans. They're really not only consistent with the house, they enhance the livability of the house as well as the architectural scheme. Are consistent with the architectural scheme. Sperling Thomas, I know we've seen these people before us, and they do specialize in the renovation and rehabilitation of older homes. So you must have an enormous market here in Milton. Hopefully you can.
In most towns, yeah.
Yeah.
So, this is, I think it's a very tasteful addition. It was well presented. I think, as Mr. Daba says, the neighbors, all who are substantially affected, all approve. It's a tasteful addition, and really, it's a rather small variation from the zoning bylaw. The variation won't have any noticeable effect on anybody. And so I also intend to vote in support of this application, and what we'll do is we'll put a condition in the decision which we write, which will provide that the addition has to be in substantial compliance with the building plans which you filed, or at least the conceptual plans that you filed. And we'll make a specific reference in the decision that the addition is supposed to encompass the entire porch area and not as shown on the plot plan. And we'll also put in there a provision, as Mr. O'Brien has rightly cautioned, that the porch is to remain a columned open porch, as you put it, and is not to be closed in without further approval of the board. So let's do the vote first. So all those in favor of granting this application for variance with the conditions that I mentioned, say aye.
Aye.
Aye. Well, congratulations on your variance. As you probably know, we prepare these decisions from scratch. We don't cut and paste. Probably take us a couple of weeks to get the decision prepared. It has to be filed with the town clerk's office. And then, even though nobody's opposed your application this evening, there's still a 20-day appeal period before you can pull your building permit. And I just caution you to deal with your designers and your builders and make sure that your variance, once you have it and once it's final, is recorded in the registry of deeds so that the variance becomes legally effective and the title to your property is kept up to date. And they can help you with that. They do that every day of the week. And if you have any questions, Mr. Prondak can help you how and where to file. So with all of that, thank you for coming tonight. Congratulations on
Thank
your
you.
variance. We all set, Ted?
Yes.
Right, yes. All right, we're going to call to order our second hearing of the evening. This is on the application of Gina Susi and Christian Limecooler. Did I pronounce that name correctly? Yes, sir. Or did I come close? Close enough. Close enough.
It was good.
Okay, it's been a few years since I took my German's
very good.
my course. And this is an application, it's dated March 21st, 2014, and the applicant's are seeking to build an 8-foot by 5-inch by 6-foot 5-inch entry portico on the front of their existing residence, which is located at 72 Badger Circle in Milton, and that particular property is located in a Residence C district. The proposed setback is 14 feet from the front property line rather than the 20 feet that's required under Section 6B3. My name is John Leonard. I'll be acting as chairman for this particular meeting. With me this evening to my immediate right is Board Member Ted Daber, and to my immediate left is Board Member Frank O'Brien. The rules of the board are that we'll first hear from the applicants. We'll hear from people who wish to speak in support of the application, listen to people who have questions of the applicant or wish to speak in opposition to this particular application. We're tape recording the proceedings in the first hearing, so please, anyone who wishes to speak, tell us your name and address, speak up nice and loud and clear in the event that we have to revert to the tape recording to write a decision. I'll paraphrase the advertisement. We'll also have as evidence at this particular hearing the application, which is dated March 21, 2014. We have our denial letter by Mr. Prondak, which is dated, again, January 31st, 2014. We have a series of plans in multiple sheets. See if I can find the first sheet. The plans are prepared by, it looks like HC Design of Situate, Massachusetts. They're dated August 13th, 2013, and they're in 4 or 5 sheets showing the various dimensions, proposed elevations, and we have a plot plan of the property. This is a site plan that was prepared by Neponset Valley Survey. It's dated October 14th, 2013, and it shows the subject property on the lot. It shows the proposed addition and the various dimensional deficiencies which are referred to in the advertisement, particularly the addition, the front setback area. Okay, so I think we should hear from the applicants. Let me welcome you to the Board of Appeals. Why don't you tell us about your application, what you're proposing, and why the board should grant you the requested variance.
Thank you, Mr. Leonard. We're currently undergoing what we're referring to phase 1 of the effort. It was kind of a redo of the house, if you will. We bought it about a year and a half ago. None of which currently in phase 1 required a variance for the lot. We did include as part of the original plan a phase 2 portion of that, and that was to cover the front entrance of the house. When we originally looked at the house, the lot slopes back in the back, and our presumption was originally when the house was built, they moved it closer to the road to be able to get it off of the slope down that happens in the back of the house. Therefore, it puts it close to the front of it puts it closer to the street than originally probably would have originally been allowed. But what we're trying to do is kind of give an entrance to the house. There's only one entrance to the front now. When we originally started this plan, there was another side front entrance, which we did away with to make sure the house stayed within the current variance and the current code of that residence. Right now, we currently only have one front entrance, and we'd like to, if possible, please put a portico over the front of that, just as a covered entryway into the front of the house. And therein lies the request for the variance, because it does lie within the setbacks of the zoning.
You talked about the slope in the back of the house. Can you describe the degree of the slope, do you know?
I think
The rear lot
the
line.
plot plan, which I don't have in front of me, it slopes down about 4 feet, and I can only assume that when they originally laid out the plot of the house, that they moved it close to the front, close to the street at that time, because it keeps it on level ground. And then as you drop off behind the basement, there was originally a bulkhead that allowed you to go back, and the lot slopes down to the corner, to the back end of the lot. So we're only presuming that that's why they put the house so close to the front of the street.
Okay, do you know when the residence was originally constructed?
It was 1952.
Okay, so it was after zoning in the town?
Yes,
but
sir.
it's still an older home?
Yes, sir.
Okay. Did you have an opportunity to show your proposed plans to abutters and other people who may be interested in the application?
We sent some notes and to the abutters of the property, the neighbor.
As many as we'd like to talk to.
Yeah, and of course, we've talked to a lot of people over the course of the last 8-9 months as the house has been constructed. And our neighbors, and we haven't had any issues with any of the neighbors to date with regard to our request for the variance.
Okay.
In fact, in late, our neighbor to the left said that he had no issues with the,
Okay, who is the neighbor to the left? You remember his
Mr.
name?
John Doherty to the left, and to the right, Mr. Rob Grant and Mrs. Susan Lewis Grant.
Robin, did you say Susan Lewis Grant?
Lewis Grant, yes.
Okay, and they expressed that they had no opposition to your
No
application for
opposition at
variance?
this time.
Okay, great. Is the color scheme of the portico going to be substantially consistent with the house and
Consistent
and
with the
all of that?
house.
It's not going to
White columns.
Okay.
I have to look to the
White trim
boss.
around the windows.
Well, you better talk
I
to
say
the boss
that-
more
I say that
about
before I-
Phase 2, because that's going to cost you a lot more than Phase 1. I'll tell you that. But let me move on and see if my colleague Ted Daber has any questions of the applicants. You don't have to have questions.
No, I know I don't have to have questions. What's the height of the, is that on there?
So it's a standard 80-inch door in the front. I think there's about 8 inches of trim above that currently right now, and I think I'm sorry, excuse me, sir, let me just. I don't anticipate the slope of the roof to be anything more than what's currently on the house, so the, it's a 12.6 rise on the roof. It's a
Yeah, but-
6-inch overhang. Bear with me, I'm stalling here.
No, that's okay, take your time.
It's pointed, so the point is so
I'm not sure if you guys were able, they were provided a set of the drawings, but I do have some here.
No, I think we
No, I
have
see
a
it.
drawing.
I know, I don't
I
think
think
they
this is
have,
helpful.
I
She
don't
didn't-
think
That's
they
all we
put the height on
Yeah.
it.
Well, that's all right. You take a reasonable guess. Tell
I
us
don't
something.
anticipate to be any more than 3.5 feet above above the current siding, which is about 8 inches above the current door,
So let's
80-inch
see,
door.
what do you think this is?
It's got to be below that, about 4 inches below that center window up there.
So how tall is it?
7 feet, 10 feet. If I had to guess, no more than 14 feet above ground.
Out of curiosity, the houses that to the left and the right of you, are they of a similar distance from the street, or?
Yes, sir.
Yeah.
Yes, sir. And the house across has is a similar distance with the portico as well. So we're kind of going along the same theme that they have, similar type portico.
Okay. I don't have any.
You should have brought us a picture of that house as evidence.
We bought, unfortunately, we brought a picture of our house, that doesn't have the portico.
Of our
on it.
house that has no
That's fine,
portico.
that's fine. Are you going to do this construction yourself?
No, sir. Bob Thomas, Star Builders out of
Okay.
Canton, is currently doing the construction, and he will complete the portico design.
Okay, you seem fairly facile with dimensions and the like, so let me see if Mr. Frank O'Brien has any questions. First question is how to get the lights on, Mr. O'Brien. Come on. So,
I was
fire
about to say the same thing. You seem fairly at home with plans and whatnot. Has this project gone on so long that you've developed that skill, or is that something?
You don't have to answer that
Are
question.
you an architect or a
I don't
builder?
understand what, you're living in a small two-family right now. I'm counting the days until whenever that day we can move in actually is. But we are very familiar with the house. We've been through it a lot, and we just have a lot of discussions with the builder, just ongoing every day as we try to wrap things up.
Looked at these plans
The only
a lot.
reason I'm familiar with it is because we've looked at them over and over. It took us about 9 months to actually get to a first set of plans, and then we moved out from there.
Okay. We're only talking about the portico here. Is it going to be in substantial conformity with this plan?
Yes, sir. It should be, I can't say exact, but it should look very similar to what you see on the plan in front of you.
What kind of stairs are we talking about here? Wood, brick,
Bluestone.
bluestone?
Bluestone.
Bluestone and some sort of masonry on the fronts, maybe brick, or stone.
So we have a picture of what's currently there. The plan is to replace it with something similar to what's already there. We have to move the stairs and align it to we had to move the top window so it's aligned with the front of the house. It was originally, they weren't centered. We moved this top center window, we centered that, and then the portico will be centered on the house, and then we'll also align obviously, we're gonna just
Stairs
take
to
what's
be
currently there, redo it, and move it over, and it's of similar granite that what you see on the front of the house
The
here.
stairs
I've
will
got a
be no
picture.
bigger than what is there now.
Here's a color picture.
Great. Thank you. Mr. O'Brien.
All right, so basically what we're talking about is, the encroachment into the front setback is no larger than what's there
Exactly.
already. What you're basically talking about, the main change being the addition of a portico
Yes,
to
sir.
cover the entrance.
Yes, sir.
Yes.
All right. So we're comfortable with the 14 feet, it's 14 inches.
Oh, did we write it
What
wrong?
is the,
14 feet, I think. isn't
14
it?
feet?
14 feet rather than 20 feet. It says inches there, but
Yeah.
the print,
wanted-
it's a
want-
scrivener's error.
Just wanted to make sure. All right, 14 feet.
Yep.
Okay. And we'll hold on to this for the record. Thank you, Mr. Chairman, I'm all set.
Okay. I just want to clarify one thing. Mr. O'Brien is a master of precision, and I just want to make sure that you followed what he asked in terms of what was being built, okay? We're going to, if we vote this variance, and it looks like we will, I guess even though I haven't spoken yet, but I'm going to support your application. It's well presented and all. It's very important that your improvement be in substantial conformity, the very technical words, with the plans that you've provided, and not similar or like or reasonably similar. So I'm just going to caution you on that, and if you're going to change your design plan to any extent here, or it's something is going to happen that's materially different, speak to Mr. Prondak and make sure that he's in accord, that what you're doing is in substantial conformity with the decision, because we don't want to have you have to file a new application and come back to amend the variance that we gave you. It's expensive and it's time-consuming, and it's not, it shouldn't be necessary.
Understood.
Okay, so any changes that are material, review them with Mr. Prondak first, and he's our first line of defense to the zoning bylaw, and he'll be very helpful to you, okay?
Okay,
So you won't have to come back to see us.
Thank you, sir.
So as I say, I intend to vote for this application. I think that it's certainly no closer to the street, and it's the beginning of, I think, a substantial improvement plan for your house. I hope we don't see you too often, but you're always welcome to come back.
Thank you.
And It's,
18 months, I think I'm tired.
okay, well, we may not be here in 18 months, but we know that somebody will be here. I think that it's well presented, and it's improvement to your house and certainly to the neighborhood, so I intend to vote for it. So all those in favor of this variance with the usual conditions, say aye.
Aye.
So congratulations on your variance. You probably heard the speech I told the first applicants who were, I'm sorry. I guess I may not have. I'm sorry. I may have jumped too quickly here in my enthusiasm for your application, and have been taken to task, rightfully so, by my colleagues. Let me just make sure, you've told us the people who are in support of your application. We just want to make sure that there's nobody present here this evening who has questions of the applicant tonight, or who otherwise wishes to speak in support of your application. And there's no such person present. Is there anyone present tonight who wishes to speak in opposition to this application for variance? Okay, so there's no such person present. So we're going to end the evidence, and we've, basically, let me hear from Mr. O'Brien. Do you want to be heard in support of this application?
I support the application. It's well presented. It's going to be a tasteful addition.
Okay, Mr. Daber.
I support the application as well, based upon the factors that you gave earlier.
Okay, well, I support the application as well for the reasons that I stated before the hearing ended. So congratulations on your variance. As I told the people at the first hearing, we have to prepare a written decision. It takes us a couple of weeks to do it. We have to have it signed, filed with the town clerk's office, and there's a 20-day appeal period before you can pull a building permit, okay? And talk with your builder or talk with Mr. Prondak regarding getting a certified copy of your variance and seeing that that's recorded in the Registry of Deeds, because then your variance will be legally effective and the title to your house will be kept up to date, okay?
All right.
Well, thanks for coming tonight, and congratulations.
Thank you
on your
very much.
variance.
Thank you, Mr.
Thank you.
Thank you. You want to do this one, Teddy?
Yes, sure, I'm happy.
Super, thank you. Mary, do you have a copy of the Mr. Galvin's filing this afternoon? I have it here somewhere. Thank you. No, I know Mr. Galvin submitted a letter originally. It's in. No, but it's in here. It's not. It's in here.
What
The original letter?
The original
Yeah,
letter.
you just flip through
I
it.
understand, but this is in Curry's, it's in here.
The application?
No,
No, the letter, the original letter. I'll deal with it.
That is in the application for the Board of Appeals.
Okay, and maybe it's here. I hope it is.
This is what you're referring to, Jim?
Yes.
The attached to that. There it is.
Okay, there it is. Okay, good, we're all set. Okay, you all set for this one?
Yep.
Frank? Oh, Mr. Prondak, hello? Yeah. All right, we're going to call to order our third and the final hearing of the evening. And this particular hearing is where's the advertisement? It must be here. Thank you. This is good. No, I have it. This is on an administrative appeal. It's brought by Jan P. Urkovic. I hope I pronounced that name correctly. Mr. Urkovic lives at 26 Walcourt Road in Milton, and he is bringing this appeal pursuant to Section 60 of the Milton zoning bylaw and Section 48, Sections 8 and 15. And he's appealing a decision of the building commissioner, which is dated March 6, 2014, when the building commissioner granted a foundation permit to Curry College to construct a new dormitory. The applicant is requesting, did request by letter in February 5th, 2014, that the Milton Building Commissioner defer the issuance of a foundation or building permit pending the college obtaining site plan approval from the Milton Planning Board pursuant to Section 7D of the Milton zoning bylaw. The applicant is also making the argument that the dormitory that's being proposed to be constructed here is considered in the nature of a lodging home, which is regulated by the selectmen of the town of Milton pursuant to General Laws, Chapter 140, Section 2223. The building commissioner wrote to the applicant here on March 6, 2014, ruling that the site plan approval provisions of the bylaw regulates multifamily buildings, quote unquote, and commercial buildings, quote unquote, but not the proposed dormitory, since it's neither a multifamily building or a commercial building, and therefore it was not subject to the site plan review provisions of the bylaw. And the commissioner also deemed that the dormitory is an educational use and has protection under the so-called Dover Amendment, General Laws, Chapter 48, Section 3, and therefore he issued the foundation permit. So this hearing is to determine whether the building commissioner's actions in granting the building permit should be annulled. The applicant is requesting that the issued foundation permit and the decision be annulled, that the permit be revoked, and that the college be directed to obtain site plan approval prior to the issuance of a new foundation or new building permit. My name is John Leonard. I'll be acting as chairman for this particular hearing. To my immediate left is Board Member Frank O'Brien. To my immediate right is Board Member Ted Daber. The rules of the board are such that we'll first hear from the applicant, and then we'll hear from any persons who wish to speak in support of the application. We'll hear from anybody who wished to speak in opposition to the application. Curry College is present this evening. We'll certainly be delighted to hear from Curry College, and we'll certainly hear from Mr. Joseph Prondak, our building inspector, who has graciously come in on his day off today to be with us this evening. We have the application that was filed with the board as evidence in this particular hearing. We have the decision by Mr. Prondak dated March 6, 2014, which we'll have in evidence. We have the actual building permit, the foundation permit that was issued. We've also secured a copy of the application for the foundation permit from the building inspector's office, so we'll have that as evidence for the hearing. I don't know whether any of the attorneys in the case have the application, but if you don't, we can make it available to you after the hearing. As part of the application, the applicant's attorney, Robert W. Galvin, of Galvin and Galvin at 10 Enterprise Street in Duxbury, Massachusetts, is representing Dr. Erkovic. He wrote a letter to us on March 13th, 2014, filing the application and in summary form describing his grievances to the issuance of the foundation permit. We also have received a letter from Mr. Galvin dated April 24th, 2014. Received it later this afternoon, so any members of the public out there probably didn't have access to it. We've provided Curry College's attorney, Robert Fishman, with a copy of this prior to the hearing tonight. We've got a copy of it here if anyone wants to see it. It's Mr. Galvin is here, and so I'm not going to read Mr. Galvin's letter because he's going to tell us what the letter is about. And it refines and puts a nuance on his earlier legal position. But we thank Mr. Galvin for all of his hard work. In addition to those materials, we did also receive a letter from Robert A. Fishman, an attorney at the Boston law firm of Nutter, McLennan and Fish on Seaport Boulevard, Boston, Massachusetts. And Mr. Fishman, in about 4 or 5 pages, recites his position regarding this particular application, and Mr. Fishman is certainly present this evening, and he's also filed basically Mr. Galvin's letter, Mr. Prondak's letter, 3 or 4 cases which Mr. Fishman believes, I'm not going to speak for him, but I think he believes they're dispositive of the issue. Mr. Fishman has also filed some plans and views of the subject property and the proposed dormitory and an elevation plan, and I see a lot of plans over in the corner there, so I suspect we'll have a much more detailed explanation of those plans as part of the hearing. So let me just suggest, Mr. Fishman, you can sit back there with your client if you'd like. If you want to come up here at the table and make yourself comfortable and have use of a table during the presentation, you're certainly free to do that as well. Sure. Hi, Mr. O'Connell. How are you? I think I said this, but if I didn't, I just want to indicate that we're tape recording the proceeding this evening so that anyone who speaks, just tell us before you speak, tell us your name and address, and speak up nice and clear and loud so we'll have a record of the proceeding. I want to welcome Mr. Galvin to the Milton Board of Appeals. I think it's the first time you've been here.
It is the first time we've been to the Milton Zoning Board of Appeals.
Well, welcome to the Board of Appeals, and Mr. Fishman, it's also good to have you here. It's a rare night that we have two newbie lawyers before the Board of Appeals, but they both come with great backgrounds and experience in land use and zoning issues, so we're very pleased, and I think that our audience will enjoy listening to 2 superb advocates tell us their respective positions. The only other thing I'd like to do is just to make sure that the non-lawyer people out there understand that this hearing is a very technical hearing on what type of review, if any, should be given to the application that was filed and the issuance of the foundation and building permit. Whether it requires site plan review under the bylaw or requires some other review, that's what we're here to figure out. But this is not a site plan review hearing. And while we'll hear on certainly from the college and maybe from Mr. Galvin, to some of the issues that kind of relate to that. We're not going to be having a site plan review hearing tonight. It's a technical hearing to determine whether the application for an appeal of Mr. Prondak's building permit decision should be granted, and if it is granted, what type of relief should be granted. So I just want everyone to be aware of that. So we don't expect a lot of people to be expressing views as to how good or horrible the proposed dormitory is, the effect of the dormitory on their site views and all of that. That may come at another day, and it may not come. It depends on the evidence here. So rather long preamble, but at least I think we're ready to proceed. And Mr. Galvin, again, welcome to the Board of Appeals. We're delighted to hear from you, sir.
Thank you, thank you. Just for the record, my name is Attorney Robert Galvin. I'm a lawyer from Marshfield, Massachusetts. My office is located in Duxbury, Massachusetts. Tonight I'm here on behalf of Dr. Jan Yurkovic and his wife Lisa Leo. They live at 26 Wolcott Road in Milton, which, just to give you a reference, is located across Brush Hill Road from the proposed area where the college is proposing to build the dormitory. Okay, we're located across the street, almost opposite where the dormitory is being built, okay? I didn't want to bog you down on a lot of details. I actually wanted to make it pretty clear because it's not a complex issue or a complicated issue. It's just an issue that's disputed. Just by way of background, I think you summarized it very accurately. We're here to appeal a foundation permit that was dated March 7th. We're here to appeal a decision from Mr. Prondak dated March 6th, which determined that the college was not subject to site plan approval. What we're not here to do is to argue with anybody that the college is not an educational use, that a dormitory is not an educational use. There's a myriad of cases that confirm that. So we'll start from the proposition, at least my clients start from the proposition that this is a use that the college has a right to build on its property.
Okay, can I stop you for 1 second? Is everyone out there able to hear Mr. Galvin, or is anybody having any difficulty hearing him? Okay, so that's great. Your tone of voice is fine. I just wanted to be sure there weren't people back there who were just grasping to hear everything you're saying.
Okay, all right. So I did want to make it very clear that we're not here to challenge the educational nature of this proposed use of the property. We certainly would acknowledge that the college will be able to build a dormitory on the property. The question is a question of process and procedure. Just by way of very brief background, I wrote a letter today because I received a letter from Attorney Fishman earlier today, which I think the board has already received. And I thought it was important to clarify a few things in light of that letter. And first and foremost was that this was not a educational use that we were challenging, it's just a question of process. So, given that's the position, I wanted to just speak very briefly about the Dover Amendment, and I'm sure you're all somewhat familiar with that, but I wanted to make it very clear that although the Dover Amendment does prohibit the town from requiring special permits and things of that nature for educational use to engage in activities that are educational in nature and structures that are educational in nature, of which these are. The Dover Amendment does not stand for the proposition that site plan approval is somehow prohibited. As a matter of fact, there are a number of cases that address this specific issue. Site plan approval, according to the Supreme Judicial Court, is defined as a regulation of use rather than its prohibition. It contemplates the imposition for the public protection of reasonable terms and conditions. It's a process that the SJC has consistently distinguished from site plan approval, from special permit process by stating that site plan approval can only be used to shape a project. And this is what I tried to point out to the board in my letter today. The point being that just because they're an educational use, and this is a dormitory is an educational building, it is not prohibited that there be a site plan review in that set of circumstances. I also want to make it very clear that there are a myriad of uses that exist that might be allowed by right, for example, in a commercial district, a commercial building, that is still going to receive site plan approval. The point being that even though you have an allowed use by right, when your bylaw requires it, site plan approval is quite normal. In this particular circumstance, we're faced with a situation, my clients, where the college is elected to place a dormitory on its property, which it has the right to do. The college has made the determination as to where it's going to be, how it's going to be located, what size it's going to be, what height it's going to be, how it's going to be screened, the type of parking that's going to be associated with it, the type of lighting that's going to be associated. The bylaw contains some definitions as to minimum requirements or maximum requirements. But there's a whole host of issues where there's some subjectivity involved. And there's no process by which, if the building inspector is correct, any of these can be discussed with anybody other than on a voluntary basis and in a non-binding way. So my suggestion was that my clients look at the plans and attempt to speak with Mr. Prondick or write him a letter suggesting that maybe site plan approval would be appropriate in this circumstance. And they did that in February, I believe, which prompted the response from Mr. Prondick. I think he hits the issue right on the head, and it is a finite issue. Is the college, just because it's an educational use, subject or not subject to site plan approval? My first answer would be no, I think it is. Second of all, Mr. Prondick has opined, and I think he did a nice job summarizing and keep it very simple for all of us, that it's not a multifamily building that's at issue here, it's an educational building. He distinguishes this multifamily, what I would say is a multifamily building, from the multifamily buildings contemplated by the bylaw by calling it an educational use that's not regulated by the bylaw. No one's arguing it's commercial in nature. Your bylaw is silent on multifamily residences or dwellings. It has no.
I mean, there's no definition of
You
it.
only have a definition of family. And your definition of family is probably even more restrictive than some communities' definitions of families, but it's fairly typical of what a family definition in a bylaw would be, albeit the number of unrelated people that could share a unit as a housekeeping unit. I don't know how the student pods would lay out within the inside of this building, because I haven't seen the internal layout plans. But I'm certain that within this dormitory, there are places where there are 1, 2, or more students that are going to live in so-called student pods together. And even though they're not related by blood or marriage, they are still sharing a unit within this residence hall as a housekeeping unit while they're here. And I would suggest that if there's a number of those units in this building, you're dealing with a multifamily building. As such, I believe that it's regulated for site plan approval by the Milton zoning bylaw. I don't think there's any dispute that state law also regulates dormitories as lodging homes, but that's not a zoning regulation. That's a simple licensing regulation. The licensing regulation requires the college to come to the Board of Selectmen in Milton under Chapter 140, Section 22 and 23, and obtain a license, not a zoning permit, a license to have a dormitory such as this. And the reason I bring this up is because in this zoning district, the lodging home would be prohibited, except it's on a college campus and this is an educational use. The second reason I bring it up is because one of the cases that Attorney Fishman cites is the Newbury Junior College case, and I believe it was cited for the proposition that the town has no right to regulate this type of use under site plan approval. That case was a licensing case, not a zoning case. And in that case, the town of Brookline and its selectmen purported to deny as a pretext someone, Newbury Junior College's ability to locate a dormitory on its property. It was educationally exempt under zoning, but they still had to come to the selectmen in Brookline and obtain the license. They were denied that license, and ultimately that denial was overturned by the SJC on the finding that there was a pretext. It's not an equivalent case or one that's particularly instructive. I agree that it's very instructive as to whether a dormitory is an educational use, but I would concede that. The bottom line for Dr. Yurkovich and Mike and Lisa Leo, his wife, is that we believe that this is precisely what should be reviewed. Failing that, there's no one to really check and examine the bona fides of the college. And I'm not suggesting in any way, shape, or form they've acted in bad faith. So I want to make that very clear. I do acknowledge, and my clients acknowledge, that the college has met with a number of the residents over an extended period of time, but they have very little bargaining position, except to rely upon the good faith of the college. And I do think there are probably a whole host of people that feel that the college has acted in good faith with them and maybe solved some of their concerns. But it avoids the issue of the process. And for me, the process is, you should have been here with the planning board negotiating reasonable terms and conditions. For example, parking. My understanding is originally the college proposed 128 parking spaces for students that are coming to live in a boarding type setting. That's far more that could possibly use the parking spaces associated with this dormitory. My understanding, which is 168, I guess, beds. My understanding is that it's been reduced down to approximately 74 parking spaces. I think that's still more than what the zoning bylaw would require. It's far more, as a practical matter, than would be necessary for people to live in this dorm where many of the prospective students won't be driving in, they'll be living there. Curry also has a number of other alternative modes of transportation, for ways to people to get to the school, things of that nature. The bottom line is certain of this parking area is located very close to some of the neighbors that are there, and there's simply no process under which this can be evaluated. I did see in Attorney Fishman's letter that the college had recently engaged a landscape architect to help work with some of the neighbors on some of the site plan issues. And when I read the parking bylaw in the town of Milton, and it's kind of extensive, it looked to me like before you design a parking area, it's supposed to be designed by a landscape architect. And my understanding, and I'm inferring some things here, is that they've just recently hired this architect. If that was a requirement that the plan be laid out by a landscape architect in conjunction with an architect and a site engineer, that didn't happen. And if people like my client don't come forward and point these issues out, that's a prime example of a problem that could develop. The other issue is lighting. I mean, the college has been there for a very long period of time. No one's looking to challenge its existence. But when a college expands into a residential neighborhood, it creates issues. And in this particular area, you're going to have light packs that are going to be on the back of the dormitory. You're going to have lighting over parking areas. And I don't know whether any lighting plan was prepared to demonstrate that light won't spill over into the abutting properties. One property happens to be a trust. I'm pretty sure they're not concerned about light spillage, but maybe they are. Again, those are not my clients. My clients are across the street. But these are some of the issues that would be typically negotiated and reviewed in a site plan approval process that aren't being reviewed. And basically the neighbors, including my client, are basically forced to accept the bona fides of the college that they've done the best they can do, and that's typically not the case. So that is my position, that Mr. Prondick was in error, because he was maliciously in error. I'm sure he exercised his very best judgment in the circumstance. We just think it was wrong, and we're asking you to overturn his decision and require the applicant to go for site plan approval where there can be some binding way of having these circumstances reviewed for the protection of the neighborhood and my clients. Thank you.
Great. I appreciate your presentation. Let me see if I can ask you a couple of questions, just so I have your position clear. I think your position is that as a matter of law, your client is entitled to have a site plan approval process pursuant to Section 8D1 of the bylaw
Yes,
before the planning board.
yes.
Okay. And you recognize, I think, in fact, I know you do, you're a very smart lawyer, that under Section 8D1 of the bylaw, and particularly paragraph 3, there are a series of conditions that have to be considered by the planning board if they were to grant site plan approval of the process.
I agree.
Okay? And, for example, the A is protection of adjoining premises against detrimental and offensive uses on the site.
Correct.
And the convenience and safety of vehicular traffic and pedestrian movement and the like. That's under 8D3 of the bylaw, which the planning board would ordinarily consider as part of the site plan review process.
It would.
Okay. But when you look at the Dover Amendment, Chapter 48, Section 3, the areas that are subject to reasonable regulation under the Dover Amendment are much more narrow and defined than they are under Section 8D of the Milton zoning bylaw. Do you agree with that?
I don't know if I do agree with that.
Okay, well, let me say this. The bulk and the height of the structure are two of the matters under Section 48.3, okay?
I agree.
And those are covered by the Milton zoning bylaw, are they not?
They are.
There are provisions as to governing what type of height and what type of bulk you could have. Yard size, lot area, setbacks, open space, all are also governed by the zoning bylaw.
Maybe if I could be very, very clear, I don't think there's any regulation in the bylaw that really governs the bulk.
You don't?
No, I mean, I think ultimately what controls here is how much they can dispose of. I mean, I agree that there's a height limitation in the bylaw.
And the relationship of the height to the other structure isn't covered somewhere in the bylaw?
There's a lot coverage bylaw, and if that's how you view bulk,
In a sense.
because I don't think we actually use the word bulk in any type of a expressly stated way.
But do you agree with me that the factors that are set forth under 48, Section 3, the Dover Amendment, are kind of factors that are readily determined by calculation, and they don't really involve discretionary fact-finding? Such as what suits the convenience and safety of vehicles and pedestrians is something that people can debate about. But when you say, what's the dimensions of the dormitory and what's the distance from the lot line, that's a mechanical process.
I agree with those type of measurements that are precisely stated in the bylaw. I agree completely with you.
So would you agree with me that if you are entitled to site plan review at all, you're entitled to the limited site plan review regarding the statutory factors set forth in Section 3, and not all of these, whether the dormitory proposes a detrimental and offensive use of the site, whether protection of adjoining premises are involved. I mean, that's not covered under Section 3.
Well, I would disagree with that.
You
I think
disagree?
I think that's too narrow of a reading of the Dover Amendment.
Okay, but the Dover Amendment does have specific categories that are subject to reasonable regulation, and you say that should be expanded beyond the language of the statute.
Well, I'm not saying it should be expanded under the language of the statute. I just think the way you're reading it is overly narrow. I think open space can be addressed in a lot of ways by a town. And I think some of it is going to be subjective in a site plan approval process. And when your bylaw speaks about protection of adjoining premises, I agree, it touches upon many of those factors. And those factors are, to a certain degree, an element of all of those features of a potential building or use. But I don't think that they should be read so narrowly that it's intended to refer to a specific standard in all circumstances.
Let me ask you this. What do you say if the board voted that Section 8D1 of the bylaw was not applicable here? That this is not a single, not a multifamily building?
Yes.
And it's not commercial. You've admitted it's not
I
commercial.
would agree with that.
So this site plan provision of the bylaw is inapplicable. Where do you go from there?
Well, we would have the option to take an appeal.
No, I know, I'm not talking about your procedural appellate remedies, but in terms of your argument that these factors that set forth in the Dover Amendment should be subject to review by somebody, and your position is, even if Mr. Prondak made determinations of these factors, somebody should be able to review that, because he'd be a judge as to himself. I think you
Well, I
mentioned
mean, I
something
think,
similar to that.
I have experience writing a lot of bylaws. I even have the distinct experience of writing some bylaws or being involved in bylaws that didn't turn out so well. And most of those ones turned out situations where building inspectors were given discretion and not specific things to check off. Where building inspectors have been asked to render discretion, for example, on expansion of non-conforming uses, those type of bylaws have failed to meet the scrutiny of the Attorney General's office. So, and I think that, I just think this is precisely what the planning board is, charged to do under this bylaw. And it's to impose some reasonable terms and conditions, including on educational uses, so that you have some enforceable mechanism to make sure that somebody does what they say they're gonna do.
Okay, well, you've made that argument, and you've made it twice, and I understand your position, but my question to you is, if we don't agree with you, and we say that, I don't know what my colleagues believe, it's just, as you probably know, we really never discuss these things in advance. But if we say that Section 8D is not applicable here, other than you're saying, well, you have got a right to appeal, and you obviously do, because we're misconstruing the bylaw, do you have any other follow-up argument there?
I don't, no.
You don't.
Our remedy would be to have an appeal.
Okay. And you do agree that the licensing argument really doesn't allow the selectman, who would be in charge of that, to essentially determine the advisability of the dormitory, or the size of the dormitory, and all of that?
There are factors that are articulated in the Newbury Junior College case that basically explain under what circumstances a selectman could refuse.
Right.
None of those circumstances are evident.
Are present here.
In my opinion, absolutely. I mean, the college is, a going concern. It doesn't maintain dilapidated buildings, and, is a.
And they're good stewards of their students. They don't
yes.
allow awful things to take place on campus.
Not to my knowledge.
Not to my knowledge either. Okay, let me see if my colleagues have any questions of you. Mr. Frank O'Brien.
Not at this time, Mr.
Okay, Mr. Ted Daver.
I have a couple, I think. There's also language, I don't believe Chairman read it, in the site plan approval provision of the Milton zoning bylaw, which says the planning board may reject any plan which fails to meet standards for health, safety, welfare, and amenities appropriate to the special needs of the persons by whom such buildings are intended to be occupied, and appropriate to the maintenance and preservation of health, safety, welfare, and amenities in relation to adjacent and other properties in the neighborhood. I mean, that doesn't fit in with any of the, or do you argue that
I
that
think
fits in with the?
I actually think that's potentially problematic for the planning board were it to try to deny site plan approval. I've always viewed circumstances where someone were claiming one of the exemptions, whether it's agricultural or educational, to receive what I would consider strict scrutiny. You have to have a substantial governmental interest at stake here, and the conditions have to be very narrowly tailored to meet that substantial governmental interest, or any condition that a planning board or a zoning board would impose on site plan approval will be struck down, particularly when you're dealing with an exempt use. I would think there'd be big trouble.
Okay, well, what I'm really asking is that something which argues against your position that site plan approval is consistent with the regulations in the Dover Amendment, which bound to follow?
Well, I think you're talking about a potential application of it rather than the concept in and of itself. And I think that there are areas where site plan approval could go awry, hopefully not with the Milton Planning Board, but I do think that there are areas that they could go awry on and have a big problem. I wasn't suggesting that, I've never suggested that the college will not be able to build a dormitory, probably in this very same area, maybe on the same footprint that they're proposing to do it now, but it might be they have to scale back some parking. It might be that the parking was designed inappropriately. It might be that the lighting wasn't designed in a way that prevented light spilling off onto abutting properties, or so that it would be visible and create a lighted sky issue. I'm going to assume that the college would probably agree to any reasonable things that anybody would propose in terms of placing baffles on lighting, lowering the height of poles, things like this. The reality is none of these things have been reviewed by anybody other than themselves. And there's no process by which I can get to that, or anybody could get to that if the college is free of all site plan review.
Okay, I just have,
I'm not trying to be evasive, hopefully I've answered your question. I do agree, in application, there's some potential problems there where the scope of site plan review could be too large.
I have not had a chance to review the cases that you cited in your letter for today's date. But a quick question, the ones that you cite on site plan review, are any of those cases involving the Dover Amendment?
Those cases are not.
Okay.
The reason I cited them was not for the Dover Amendment issues in and of themselves. I cited them for the proposition that site plan review is completely different from a special permit circumstance, which is clearly prohibited by the Dover Amendment. As a matter of fact, the Zoning Act in and of itself doesn't even mention the term site plan review. And the other case that I said, the Prudential Insurance case, which involved the Board of Appeals over in Westwood, that was a case that just basically stands for the proposition that even a use that's allowed by right can still be obligated to go through site plan approval.
Okay. And are you aware of any cases that in which a court has held that site plan review is appropriate in a
I think it's probably a little bit clearer in other cities and towns concerning site plan review. But site plan review does go on, and I believe there are circumstances over in Chestnut Hill where you see, under a very different zoning act, the city of Boston or the city of Newton looking at some of the things that a college like Boston College would do under a different set of bylaws that look very different and maybe much clearer than what we have here.
okay.
Right, but Boston isn't covered by the Dover Amendment.
It is not.
It's expressly exempted.
I was trying to give you an example
Sure.
that there are other places where site plan review does occur.
Oh, okay, well, I was referring to appellate, by
I'm not-
cases, I meant appellate.
I'm not
cases.
aware of any single case
Land
that's
court
squarely,
cases or-
I'm not familiar with any specific case that says, a college is exempt from site plan review at all.
Or then it could be made
Subject.
subject to site plan review. In other words, no case either way.
I'm not familiar with that case,
Okay.
either way.
All right, thank you.
Mr. Prondak, first of all, thank you, Mr. Galvin. We appreciate your presentation and your candor in answering questions. Welcome to the board. I'm glad to have you here tonight.
Thank you.
Do you want to be heard on this appeal,
I
since they're
probably
appealing your
should.
decision?
Yes.
And then we'll hear from the college.
Well, the entire basis of my decision to issue this permit and potentially future permits for this dormitory is based on the fact that I do not believe this qualifies as a multifamily dwelling. And site plan review specifically carves out multifamily dwellings and commercial buildings. This is not. It is an educational use, is accessory to the college. And I had a conversation with Attorney John Flynn, Town Council, back in 2006 about this entire scope. It was prompted by some things that were going on at Milton Hospital at the time. But based on that conversation, I further believe that the Dover Amendment doesn't even come into play here because the educational use is so expressly permitted by a zoning bylaw. And according to Town Council, consistent with the Dover Amendment, our bylaw does impose reasonable regulations on educational uses by virtue of setbacks and parking requirements and height and area limitations. So my entire decision is, again, is based on the fact that I do not see this as a multifamily use. Just as I wouldn't see perhaps I could draw a comparison towards if a religious use were to build, say, a church and then a convent for the nuns. I wouldn't view that as multifamily either. I would view that as accessory within the religious category. So short and sweet, that's my entire basis.
Okay, thank you, Mr. Prondak. I just have a couple of short questions for you. And that is, and I just want to make it clear from the record, this conversation with Mr. Flynn, I'm hurting myself here, excuse me. The conversation with Mr. Flynn was in 2006 and related to Milton Hospital.
Well,
And didn't relate directly to Curry College or any.
Well, we spoke specifically about educational uses in the Dover Amendment.
Okay, all right. But is it fair to say that you haven't spoken to Mr. Flynn with respect to this specific application? Is that fair to say?
That's correct, I have not.
Okay.
I would also add, if I could just add one other thing.
You can add anything you want, Mr.
There
Prondak.
are two dormitories built by Curry College, similar in size, prior to my tenure. They could perhaps provide the addresses, but I believe they're called North Campus Residence Hall and South Campus Residence Hall, or something of that nature. And those were not subject to site plan review at the time either. But they are more recent buildings, site plan review was in effect. My understanding.
Okay, there was, is it fair to say to both parties here that there was no controversy over the construction of either of those
I was not here at
dormitories?
the time, so
So you don't know?
I don't know.
Okay, you don't know whether anyone was asking for a site plan review or it just didn't come up?
I don't know.
You don't know, okay. Let me ask you this, when you were presented with the application for, I guess it was a foundation permit and a building permit? Or was it just a foundation?
Building permit for the foundation only.
A building permit for the foundation, and then is there a second permit that gets issued at a later time?
Actually, there may be several in this case.
Okay, what are the other,
There is
what
now-
are the other permits?
There's now an application in for what we call a shell permit, which is fairly standard in the industry. And that basically entitles Curry College to build the shell of the building, the basic walls and roof
Just
structure.
the facade?
Yes.
Yeah.
While they have the remaining features of the building, like the HVAC systems, the fire sprinkler systems, in all of that designed.
Yep.
So there may be a third permit as well for various finishes and mechanical installations.
Okay. When you received the foundation permit, you recognize, do you not, that the Dover Amendment provides that certain factors can be subject to reasonable regulation by the town?
I do.
Okay. And those factors are yard sizes. Let me start at the beginning, not in the middle. Those factors are bulk, height, building coverage requirements, yard sizes, lot area, setbacks, open space, and parking. Okay?
Yes.
I tried to read them correctly, I hope I did. But those are the substance of the factors that are considered. When the building permit was presented to you, did you look at the building permit with respect to those particular factors and what the bylaw requires regarding those factors and make determinations that the application conformed to those factors before you issued the building permit?
With respect to building height, setback, and
Yeah.
open space,
Bulk, height, yard size, lot area, setbacks, open space, and parking, and building coverage.
the short answer is yes.
Okay.
The only thing is that the parking plan at the time was not complete, but I was presented with a parking plan that showed, that likely showed compliance, and was a cursory review, knowing that a further refined parking plan was coming. But the college was well aware that they needed to comply with the parking, because I did ask for a zoning analysis specifically on parking with subsequent permitting.
Okay. And is it true that the statutory factors under the Dover Amendment, you were able to determine compliance with those factors based upon the plans and documents that the college submitted as part of that application?
That is correct.
Okay. Did you make any formal written findings of compliance of these factors, or did you just find that they had been complied with and moved on?
Found that they were complied with and moved on.
Okay, so there's no written document that you prepared, and no formal decision that you prepared on those factors?
No.
Okay. The latest iteration of the parking plan that you received, and we probably have never received it, I understand, Mr. Galvin, but in your opinion, does that comply with the provisions of the Milton zoning bylaw?
I have not done a full review on that yet.
On the
so-
parking.
On the parking.
Okay. Okay, so that's still outstanding?
That is pending. And I'd also like to add that it is standard within the industry. Foundation permits are very common in every city and town. They are often issued with the understanding that this is a foundation permit. It does not guarantee you that you're going to get a permit for the rest of the building. And it's basically done at risk, at the applicant's risk.
Okay, so the applicant would build a foundation, maybe get a facade permit, or whatever you called it. You called it a shell permit, and then before they could get a final building permit and a more detailed permit, they'd have to show you compliance with the parking requirements of the bylaw.
And everything else that's governed by the bylaw.
Okay. Thank you. I don't have any questions. Let's see if my colleagues have any questions. Mr. David, do you have any questions of Mr. Prondak?
As I was reading it, one of the things that I was interested in was in the plan on which the setbacks are shown
Oh, I'm sure.
shows, what?
No, I'm
Shows a
sorry.
large lot, which I think is indicated to be 9-point-some acres, and I was just wondering where that lot came from. I mean, in other words, we shown an indication of how the lot was delineated by Curry? I mean, is that a lot that was deeded in that particular form or subdivided themselves?
I believe it was.
Maybe that's a question for Attorney Fishman. I was just.
I believe it was that Curry College owned a portion of that land. It is somewhat adjacent to their existing student center, and then they purchased additional properties.
Okay.
On Brush Hill Road, that then become contiguous.
Okay, but a lot of the calculations arise from that, I think, that were made, arise from the size of the lot and what's, what was already on the lot at the time of the application. So I was just curious as to how that, the lot was determined.
Well,
But I can ask
in
Attorney
the open space
Fishman.
portion of the bylaw, it talks about a particular lot and it's.
And it's,
adjoining-
right, I realize that,
So
yeah, but some of them don't, I believe.
If,
some of the provisions.
if you were to take the totality of the Curry College campus.
Right.
There's a fair amount of compliant
Right.
open space.
Right. No, I realize that, but some of them don't. Okay, that's all I had, thank you.
Mr. O'Brien, do you have any questions?
I have a couple, thank you, Mr. Chairman. Joe, how long have you been the building inspector in the town? Building commissioner, inspector, what have you?
Since 9/11/06,
And prior to that point in time, how long have you been a building inspector in total?
19 years prior to that.
Was there anything unusual about this application? I mean, we're used to dealing with, coming before the board, we had a couple of relatively routine cases earlier in the evening with back porches and stuff like that. The size of this particular project, is this unusual for the town?
I don't believe so. I view this building as similar to two of the newer dorms on Curry College campus. It's really the only college of this size that we have. So I don't view it as unusual, given the overall use of the property.
We have a couple of other large facilities in town, the hospital, Milton Academy, for example. Have any of these other institutions in the town had a similar facility or a building constructed that was subject to site plan review?
Milton Academy, for example, they haven't built any dormitories. They did build a science center recently
In the Knott Center, I think, didn't they?
um,
Well, may call it a cultural center or whatever it is, but it's a musical center where they are performing
that may have been
arts.
prior to my tenure.
Okay.
But no, those buildings were not sent for site plan review. Milton Hospital is subject to a special permit as a philanthropic use.
I'm well aware.
However, they were not subject to site plan review as well. And that determination was made just before I got here. I came when Milton Hospital was in the middle of their large expansion.
So you're unaware of any site plan reviews for, if you will, roughly charitable educational institutions in the town, at least in your tenure?
I'm not aware of any.
Relative to the issuance of the foundation permit, et cetera, pending a fuller review of the parking plan and other details, is it unusual to issue a permit for a specific step in a project?
No, it's very common in the industry today.
And why is that the case?
I think it's more a matter of economics. It's easier to design a system for a building, I think, once the building is up and going, or perhaps Mr. O'Connell could speak better to that. But, for example, an office building, you would build typically a shell of the building and then build out each tenant space as tenants came about. So there's a number of reasons why you would do it, but it is very common.
Have you had permits or applicants come to you and you have ruled that a site plan was needed?
Yes,
Can you give me an example?
50 Elliott Street, 36 Central, both multifamily, 50 Elliott is multifamily, 27-unit multifamily building. 36 Central is a multifamily / mixed use. There's some commercial spaces as well. Those are two that come to mind off the top of my head. I think we had site plan review for some expansion at the Fruit Center. Renovations of the gas stations down by the Fruit Center, all subject to site plan review. And now I'm drawing a blank.
That's fine. So it's not unusual for a project to have site plan review, but it doesn't seem like it's not unusual for a project not to have site plan review, at least in your experience in this town.
That's correct.
So, other than it's Curry College and it's an educational institution, there's nothing particularly unusual about this particular application?
I don't believe so.
Okay. Thank you, Mr. Chairman.
Mr. David, do you have any follow-up questions? Okay, thank you, Mr. Prundock. I don't have any further questions of you. You're going to stick around here?
I am.
Good, would be delighted to have you do that.
Mr. Chairman,
Yes, Mr. Galvin.
may I ask one question through you to Mr.
Of course you can, of course.
You would, and I want to say one thing and then I'll ask the question.
Sure.
You had asked me before how the Dover Amendment might weigh into the issue of parking. Well, parking in your bylaw has a set of design standards, H1 through H10. So I'm dealing with parking surfaces.
So what page are you on, Mr. Galvin? So my notes will be up to
Page
date.
89 of your bylaw.
Yep.
Section 7H1, there are 10 standards for how a parking lot is supposed to be designed. A lot of these things don't contain necessarily minimum standards, but they are standards of the Milton bylaw. And the one that I brought up even before Mr. Prondak spoke was that parking areas have to be designed by 4 different areas of discipline. And the question was, the plan that was received, did it bear the stamp or signature of those 4 different disciplines? And that was the question I wanted to ask.
Sure. Do you understand Mr. Galvin's question?
I'm not sure I understand the question. I would disagree.
Let me see if I can paraphrase the question, then you can express your answer. I think what Mr. Galvin is saying is that the bylaw for setting forth parking has rather detailed standards for the design and the appropriateness of parking. And Mr. Galvin contends that you may have to have an architect to get involved in that, and maybe, depending on the complexity of it, maybe a traffic engineer, or you have to have sophisticated planning for parking. And I guess his question is, since that hasn't taken place here, we agree that hasn't taken place, how can you make determinations that the parking is adequate when you grant the foundation permit or a shell permit, and shouldn't that type of analysis be done before a permit is issued? I think that's the essence of his question.
That was the essence of the question.
Okay, can you take a shot at that, Mr. Prondak?
Procedurally, again, the foundation permit is issued at their own risk. Curry College is, at least Mr. O'Connell, is aware that any subsequent plans and permitting have to completely comply with the bylaw.
At what stage of the construction process would you be concerned that the parking lot, you'd be concerned with determining whether the parking lot is in compliance with the bylaw?
That will be this next phase, the shell permit.
Okay, at the time a shell permit is issued, then you'd make a formal review and a technical review of the parking?
That's correct.
Okay, and you find it to be compliant, you'd issue a shell permit?
Yes.
Okay. What if Dr. Erkovec or some neighbor, some abutter, didn't believe that the parking that you have approved of didn't comply, it did not comply with the bylaw, that you erred on granting the shell permit because the parking lot was not properly or fully or technically designed? What would be their remedy under those circumstances?
Well, first I would go back and see specifically what they were inquiring about, and see if I did in fact err.
Okay, so if they came to you, whether in writing or in person, that expressed their position to you, and then you'd do what? You'd make a ruling, or?
I would re-review the submittals.
Okay, and let's assume the hypothetical is the person says, well, Mr. Prondak, I disagree because a traffic engineer didn't stamp these plans, or that an architect didn't prepare these parking plans. And then you say, well, I think they comply with the bylaw. And they say, well, I think they don't. What is the person to do then? Challenge the building permit?
It's possible that they could.
Or file an appeal with the Board of Appeals that you're not enforcing the parking requirements of the bylaw?
Yes, I guess that's always an option. But all of the plans on this building have to be stamped by an appropriate disciplined design professional, whether it be a landscape architect, a civil engineer, structural engineer, mechanical engineer.
And that includes the parking plan?
Includes the parking plan, yes.
When would you expect the shell permit to be applied for in this particular process?
It has been applied for.
Oh, and so that's the new parking plan that you say you've reviewed?
I've received.
You've received? Okay, okay. Mr. Galvin, does that answer your question? I'm not,
Yes,
not whether it's satisfactory, but did it answer you?
I appreciate that. All I wanted to say, I guess in follow-up, is that, this is kind of precisely the issue. Even though it might be easier for the college to construct it in this fashion, I dare say it probably makes it more difficult to undo the problem or adjust the problem if it doesn't comply, if you fix the location of a building on the ground. That was the point that I'd like to make.
Okay.
That I'm all set.
Okay,
Thank you.
that's fine. I don't have, do you have any questions for Mr. Prondak, Mr. Deva? Any further?
No other questions. no.
Mr. Ryan, you all set? Okay, thank you, Joe. I appreciate your answering that question. Mr. Fishman, you stayed around to be with us. It's good to have you before the Board of Appeals. We're delighted to hear from you.
Thank you, Mr. Chairman. I'll try to be brief. Excuse me. I filed a letter with you that you acknowledged, and hopefully the board members have had a chance to look through it, as well as the exhibits. If I can very briefly, for the record and for the audience, state the college's position as succinctly as possible.
Sure, but let me tell you this, Mr. Fishman, and I say it in all sincerity. We love to get home early and watch the end of the Red Sox game, but there are some things that are more important. So you take your time with your presentation and make whatever presentation you deem necessary. Sometimes we till 10:30 at night. I hope that's not tonight, but you take your time.
Fair enough. Well, first of all, thank you for your invitation to sit at the table and to participate. We believe the building inspector correctly interpreted our zoning bylaw, and so we urge you to affirm what he has done and to dismiss this appeal. As stated in our letter, and as Mr. Galvin has indicated, we are a protected use under 40A Section 3. So the use itself is allowed. There's no debate about that. In our view, while we're happy to talk about more things, it's really a very narrow, simple question, which is, did the building inspector correctly interpret your zoning bylaw? And we believe the words speak for themselves. The trigger provisions of site plan review, we talked about, Section 8D1, only subject to site plan approval of a multifamily building, which this is not, or a commercial building. That basically is and should be the end of the discussion from a purely legal standpoint. You don't even reach a Dover Amendment argument. You just read the Milton zoning bylaw, read the provisions. An educational use is regulated under a different section. It's referred to in our letter, and we can look at provisions with Roman numeral IA9 and Roman numeral 3A3. It is defined as a separate use category and is distinct from a multifamily dwelling or commercial. And as I'm hearing tonight, Mr. Galvin isn't even arguing to the contrary. So by the words of the bylaw itself, it is not subject to site plan review. If you got to the question, even for argument's sake, that if it did attempt to subject this type of use to site plan review, the law is very well settled that a municipality may not subject a protected Dover use to either special permit or site plan review or an informational statement. The well-settled case, which I've attached, is Bible Speaks Against Board of Lennox. And just to quote one of the key sentences in the case, there's nothing in the language of 48.3 which contemplates the requirement of site plans and informational statements as monitoring devices for educational uses. The appeals court further reasoned that the zoning board of appeals could not use the town of Lennox zoning bylaws to impermissibly impede the reasonable use of the institution's land for its educational purposes. And to the point that one of the board members was asking, and forgive me if I forget what you asked us, the reason for that and the reason for the Dover Amendment is to prevent municipalities from discriminating as between either religious uses or different types of educational uses. And to the very point that I believe it was Mr. Dibner, was it?
Mr. Daber.
Daber, I apologize. And you focused in on the exact language I was going to point to in your site plan provision, that your site plan provision allows for rejection of site plans if certain subjective provisions are not met. That goes way beyond what 48.3 says. And the chairman correctly quoted the zoning, the 48.3. And as the building inspector has indicated, and we have other plans we've sent you and other copies here, just a little bit bigger size, a little bit easier to read, that where there's no argument as to whether we're subject to the reasonable bulk dimensional parking open space requirements of the bylaw. We are subject to those, and we comply with those. We're not asking for a variance. We're not asking for what's called a determination of balancing the municipality's interests against the impact on the institution, which is the Tufts College, the balancing test. We're not claiming any of that. To your point, the purpose of 48.3 is to say there are objective requirements that are set out in a zoning ordinance or bylaw that the protected use needs to comply with. And assuming it meets those requirements objectively, as a matter of measurement, it is entitled, just like any use, any structure. If you meet the bylaw, the dimensional, the parking, you're entitled to a building permit. This is a no different situation. We're not asking for a deviation from those requirements. And the point of the site plan provision, and I think exactly what Mr. Galvin is asking for, is so that there could be a forum in which discretionary, subjective conditions could be imposed on this type of organization, and that is precisely what is prohibited by the Dover Amendment. That's exactly what's prohibited by it. And he doesn't address in any of his letters to you the Lennox case, the Bible Speaks case, which is directly on point. It's not a Superior Court case, it's an appeals court case, and it has been cited numerous times thereafter. It's the seminal case, where, well, I won't go into the facts, the case speaks for itself, but that stands for that proposition. And it's for that reason. There's not to be bargaining that goes on about appropriate conditions if the institution, whether it's a church, a synagogue, in this case a nonprofit educational institution, meets the objective requirements of your bylaw. And I would point you, I think this was emailed around yesterday, but I have larger copies. This is the site plan that is the more detailed site plan that's part of the building permit application, I guess the shell application, to use the building inspector's phrase. There are charts on it that show what the zoning requires, what the section is, how we comply with respect to each of the criteria the chairman read, as well as parking. So we're not asking for any relief. We objectively meet that. And I think where Mr. Galvin misreads the law and asks you to frankly create a precedent that I'm not aware of in the Commonwealth of Massachusetts, is that it is the building inspector's job as the chief enforcer of the zoning bylaw to determine in the first instance whether there's compliance with the zoning bylaw. It is not the job of the planning board to determine whether a zoning bylaw, in terms of these factors, does the dimensional table satisfied, are there enough parking spaces? That is the building inspector's job. He enforces the zoning bylaw. And if someone, to your question, Mr. Chairman, believes that he has misinterpreted the zoning or misapplied it, then they're right back here. If he looks at our parking plan and thinks it meets these standards, and it turns out he's wrong, then the recourse of anyone aggrieved by that is to come back here. And we'll have that discussion. We have tried to foreclose, frankly, us all being back here again by pointing out to you that even though it may not strictly be before you tonight, because the only question is, are we subject to site plan review? We have frankly gone beyond that and said, well, let's now actually go to the next stage. Sort of a combination of what you found at the foundation permit stage and what hopefully you're about to find at the shell permit stage, and say, let's assume we're back here 2 months from now. We're showing you that we do comply with these. So let's foreclose a waste of everybody's time, if I can be blunt, right now, because we meet. We're not asking for any relief from that. Finally, while it's not strictly the matter before you, I just would refer you to Section 3 of the college's letter. The college has met numerous times with the neighbors, over 7 meetings. There have been landscape architects present at these meetings. There have been many changes to the design of this dormitory to meet the concerns of the neighbors, to try to mitigate impacts to the greatest extent possible. We articulate 7 or 8 changes specifically that have been made to do that. I direct you both to the plan we sent you today that you asked for. I have larger copies here, if you would like. We have the elevation plan that is an exhibit to our letter, but we also have a larger copy on a board here, if you want to look further at that. What may not have been apparent, and wasn't apparent to me until I went out and took a site view myself, is the college has bought two large residential properties that abut Brush Hill Road. And this dormitory sits in back of those. So if you were looking at the site as you saw from Brush Hill Road, you see these two large houses that one is their admissions office, the other is being integrated into and as part of this new dormitory. The dormitory sits at an elevation well below those houses, so that the roof of the dormitory, which meets zoning, does not exceed zoning, is actually, and it said in our letter, it's 17 and 19 feet respectively lower, less high, than these two existing houses that front Brush Hill Road. So between these houses basically acting themselves as a buffer, the dormitory being down below that at a lower elevation, and extensive landscaping that is being installed along Brush Hill Road, the college has taken great pains, albeit with input from the neighbors. You know, we would be less than candid to say changes were not made in response to these community meetings, but these were initiated by the college, and they've taken to heart much of what they've heard and have done, you know, many different things to try to mitigate these impacts, including just one statistic. This building is set back 4 times greater from Brush Hill Road than your zoning allows. This building could be 45 feet from Brush Hill Road. It is 205 feet from Brush Hill Road. So the college has tried to be very receptive. I don't disagree with Mr. Galvin that these are measures that the college is voluntarily taking, but that's what the law is. And they're trying to be a good corporate citizen at the same time as they have important institutional needs that they're seeking to meet, in which I think by his own admission, the college is entitled to meet. So that's basically what I would like to say.
Right, let me do 2 things before I forget about them. Number one, we would like to have larger copies of the plan. I was looking at your site plan this afternoon, and
Sure.
I have to
I
confess, I
had
had
to blow it
difficulty
up.
reading
Do you want
it.
one for the record, Mary, or, so I have 3 for the board and 1 for
Thank you, and
the
could you favor Mr. Galvin with a copy?
Absolutely.
And likewise, the,
Building inspector?
Joe has it. The other plan there, the smaller
Yep.
version of that, would like to have that as
Yep.
part of the record as
Okay,
well.
so this is, Bob, am I right? So I should have said for the record, Bob O'Connell, head of buildings and grounds for Curry College.
Well, we know Mr. O'Connell, he's been here a few times.
Bob Fishman of Nutter McLennan, a little belatedly.
That's all right.
So this is a blow-up of one of the basic site plan sheet to the building permit set. And I have had this blown up as much as our office was able to do it, and I don't, even with my new progressive lenses, it's still a little bit of a struggle. But I have read it, it does comply, in my opinion, it does comply with the law. Let's see, what do you need?
No, I think we're doing great. One of those, Mr. Galvin, and
Mr. Galvin?
yeah, that's a large one.
Right, so just to walk, not line by line, but to show you what's here. So the upper left-hand block is, you know, what is the section of the zoning bylaw, what is required, and then obviously the right-hand corner column is what have we provided. The middle block is the calculation of the open space and building coverage requirement. And then in the lower central part is the calculation of how much parking would be required to meet the parking bylaw requirements as to number of parking spaces.
Great, thank you very, very much. Let me, Mr. Fishman, let me see if, Mr. O'Brien, do you have any questions of Mr. Fishman at this time?
For now.
Okay. Mr. David, do you have any questions of Mr. Fishman?
Yeah, I have a question about the site. Assuming it were subject to site plan approval, or we found that it were. I ran across, I believe it was a land court case, which indicated that in a case of site plan approval, it almost seemed as though you could cull out what were reasonable regulations that were within the scope of the factors that the statute said could be considered. would you agree with that? That you could kind of pick and choose and call out certain portions of a site plan review provision that were consistent with those dimensional regulations and make them applicable?
No, I'm not familiar with the case. It's not an appellate
It
case
was
if it's
not
a
an
land
appellate
court
case, no.
case, but I'm
Okay.
not familiar with that case. I think my initial reaction is no, under the Lennox Bible Speaks case. I think when the statute uses the word reasonable, what that's actually talking about is reasonable as applied. So, not to get too technical or professorial, but by happenstance,
Professor, get technical and professorial.
Okay, well-
We're all lawyers here.
all right, so by happenstance, our office was involved in the Tufts College case, which is the leading Dover Act case, and we handled it up to the SJC. And what the SJC said is that, I guess to give you an example, if in a residential district, which is what actually this is here at Curry as well, in that case it was Tufts College, if, let's just say, the height limitation was 30 feet, and actually I handled this case for Tufts, they wanted to expand their athletic center to allow indoor tennis and some other activities like that. Well, you can't do that with a 30-foot high roof. It has to be whatever it is, 60 feet, whatever, more than 30 feet. So what and I think the building inspector knows this, and that's not our case here, but just in terms of what the word reasonable means, it's basically if the use is protected, in that case, an athletic facility at a college, if it cannot comply with that height limitation, then what the building inspector is supposed to do is do a balancing test. On the one hand, the building inspector weighs what was the purpose of the 30-foot height limitation? You know, what's the municipal interest in it? And he's supposed to weigh that against what is the impact on the protected use. In that example I gave you, it would prohibit the protected use. You can't have a field house with a 30-foot high roof and have it be a field house that meets intercollegiate standards and all that. So in that case, actually, the law is the building inspector, in the first instance, is supposed to say, you don't have to be 30 feet high, because it's not reasonable to apply a 30-foot height limit to a college field house. Some building inspectors will do that, in my experience. Others will say, I'd rather the Board of Appeal make that decision. But at the end of the day, it's a balancing test. It's a balancing test, and it's not even a special permit. The court uses the term a determination. So if we were building a field house, or if we were building a dormitory that didn't meet the height limit here, and we wanted to build 2 more stories, we would come here and have to make a case to you as to why the residential height limit, as applied to the college, was unreasonable, and you'd have a decision to make. You know, you weigh those factors, density, relationship to the neighborhood. That's what the word reasonable means in the statute. It's the determination that in the first instance, the building inspector is supposed to make. It's not what a planning board
You're
thinks is
saying that as a
reasonable.
matter of appellate law, the planning board cannot apply that balancing test or make that determination.
That is my opinion.
But your opinion is also that if you'd come before the Board of Appeals, but you wouldn't be seeking a height variance.
Correct.
You'd be seeking a
determination,
determination
that's
under
correct.
the Dover Amendment and the factors of the Dover Amendment that the height of the new structure should be 45 feet or 50 feet in order to accommodate the tennis balls or lobs
Yep.
or whatever they do in tennis. I'm not a tennis player.
Nor am I. That's exactly right.
But it's, so that's kind of a unique situation that the board would be making a determination under the Dover Amendment that this is proper, but it wouldn't be a special permit and it certainly wouldn't be a variance.
Yeah, and I think it's frankly often misunderstood. And I've seen situations where people apply for variances in those situations. They actually shouldn't, as a technical matter.
You
It's
mean
not a variance.
educational,
Yeah,
well, they should be seeking your counsel and
Well,
not the counsel of others.
thank you. Can we get that on our PR page, Robert?
Well, we have a tape recording
All
that's
right, there you
available
go.
for purchase.
So go viral on YouTube right away.
I tell you, I'm just pleased that I understood the distinction you were making. That's, as long as I understand what the lawyers are saying, that's partially helpful. Mr. O'Brien, do you have something to say here?
I always have something to say. A couple of questions. So I'm not a land use lawyer, okay? I'm a lobbyist. I do.
Don't hold it against Mr. Fitzgerald.
Some of my best friends are.
I'm talking practical politics. So let me understand your argument, okay? And please, be technical, be professorial, as I've learned a lot from my colleague to my right about land use law. So your argument is basically twofold. One, that this structure is not a multifamily structure under the terms of our zoning bylaw.
Correct.
And it's your argument in the first instance that the analysis ends there.
Correct. If you read section 8D1A of your bylaw, what I call the trigger provision, what's the jurisdiction of the planning board?
Read it for me, please.
No multifamily dwelling, excluding two-family residences, but including attached single-family residences, shall be constructed or externally enlarged, and no area for parking, loading. Want me to read the whole thing?
No, that's fine.
Okay. Shall be done, I'll paraphrase, without a site plan bearing the endorsement of the planning board.
All right. So the whole analysis turns on the word multifamily. This is not multifamily, and that's, I think, a position that Mr. Galvin would disagree with. Now, going on from that, assuming for a moment that we don't agree, just for the sake of argument, that we take a different point that it is a multifamily structure. Your secondary argument is that even if that is the case, because it is an exempt educational use, that under the Dover Amendment, only the simplest, most objective standards could be applied to this. Things like setbacks, parking, things like that. Very simple, I'm paraphrasing it, very simple, non-judgmental kind of things could be subject to this particular structure. And things like, it looks awful, can't go into the analysis. Isn't that what site plan review is? Is your argument that the application, a site plan review is in and of itself a judgmental process, and then under the Dover Amendment, a judgmental process cannot be utilized for an exempt property?
I'm saying that, as one of your own colleagues pointed out, the standards for site plan review in your bylaws, section 3A through F on pages 94 and 95, are subjective and have nothing to do with what 48.3 says, and we're not disagreeing on what we may be subject to. We may be subject to reasonable regulations concerning the bulk and height of structures, exact quoting, and determining yard sizes, lot area, setbacks, open space, parking, and building coverage requirements. If a exempt use, a Dover use, meets those enumerated requirements of your zoning bylaw, it is entitled to a building permit.
Period. End of
Period.
story.
End of story.
All right. How do you distinguish what you refer to as the Bible speaks, the seminal case, on the Dover Amendment to site plan review or not to site plan review, versus some of the other cases that Mr. Galvin has cited, the YD dugout,
Yep.
The Prudential Insurance Company? I mean, first, there may be many who think in this town that YD Dugout is a charitable institution, but it is not. And I can tell you from experience that Prudential is not a charitable institution.
Great.
Would that be the main, or charitable or educational institution? Would that be the main distinction between the two cases, or?
No, I'm sorry, I didn't mean to speak over you.
Go ahead.
So, it's basically, we're taking position A, and I believe Mr. Galvin is over here taking position B, because they don't engage. I think one of you asked him, I mean, YD Dugout and Prudential are site plan review cases. So, those projects were subject to site plan review, okay? We're not. Okay? Those cases then go on to a situation where a use that was subject to site plan review encountered situations with the boards, either, as I recall, imposed conditions that the applicant thought were unreasonable, or those were permitted uses permitted by right, subject to site plan review. With me? Sorry, should I go on?
Yes, we understand. Go
And those were cases in which I believe in one of those cases, the board actually denied site plan review to a use allowed by right under the table of uses. And in the other case imposed conditions, as I recall, which the applicant thought were unreasonable. Okay? In those cases, the applicant challenged the decision of the board on site plan review. And those cases stand for the proposition that if you are subject to site plan review, and if you are a use otherwise allowed by right, that the board may only impose reasonable conditions and cannot impose conditions which are so onerous that they effectively prohibit the use that's permitted under the table of uses. And there are only two narrow exceptions to that principle of law, or the holding by the court. One is if the application is incomplete, and the other is, and now I'm quoting, I may not have the exact quote, but I remember these words, if the problem is so intractable, that was the word the court used, so intractable that no amount of conditions imposed by a board could basically ameliorate the condition. And it's almost always traffic. That the intersection is just so bad that no amount of money you could throw at it to reconfigure the intersection, new traffic lights, would fix the problem, which I believe is the Prudential case. Okay? So that's what those cases stand for. Those cases do not involve a Dover situation. I think one of you asked, do you know of a Dover case, or are those Dover cases? Those were cases in which you had commercial uses subject to site plan review. And the issue was, what's the standard by which the board makes its decision? We don't reach that point. We're way over, a much earlier stage, saying we're not even subject to site plan review.
Yeah.
So I think when I say I'm over here, Mr. Galvin's over here, I don't even get to those cases because I never go through the gate, if you will.
Thank you, Mr. Chairman.
Mr. Draper, do you have any further questions?
No other questions.
Okay. Thank you very, very much, Mr. Fishman. We appreciate. As all of the lawyers here have acknowledged, we're dealing with very technical issues here, dealing with the Dover Amendment and decisions of the appeals court and the SJC and the like. But the attorneys have basically finished their presentations. So I just want to ask is whether there's anybody out there who wants to be heard on the technical legal issues that are before us here. If you do, just raise your hand and you'll have to come up here to the microphone and say what you need to say. Okay, so the record indicates that nobody wishes to be heard on the legal issues, the technical issues that we've been discussing here. Okay, so with that is, and thank you very much. I appreciate you coming here. Let me do two things. Mr. Galvin, let me give you a final shot, not to repeat what you've said, obviously, but if you have any concluding comments, I would be delighted to hear from you. And then we'll ask Mr. Fishman whether he has any comments, and we'll adjourn the so-called evidence portion of the hearing, and we'll see if we can decide this case here and now. Please.
I just don't really want to take any more time and duplicate things that I said. I think the board kind of understands the distinction between our two positions. The only thing new that I heard tonight that I didn't know before was, in fact, that the foundation permit did issue without all of the plans being in place for the parking. I think that's something separate. I would rather not have to raise it in a separate issue, as a separate issue, if it can be addressed. Maybe it'll be cured. I don't know, but.
Or maybe it could be addressed informally if it comes up, but we're dealing with the legal issues here of the nature of the.
I think the board all asked the questions that lead me to conclude you understand the distinction between our two positions.
Okay, great. Thank you very much. We appreciate your presentation. Mr. Fishman, do you want to say a final word?
Just not to prolong things, just one, Mr. Galvin referred to the Newbury College case that I cited to you. So I wasn't citing that for the proposition that he articulated in his letter of late today, because I thought his appeal initially, his argument was lodging house includes in its definition dormitory, therefore dormitory is subject to site plan review. And what I was trying to point out in that case, which I thought was directly on point in this respect, that the court drew a distinction between the purpose of the lodging house statute and zoning. Those are two different things, and the court sought to reconcile the different roles of, in that case, zoning and the role of the Board of Selectmen in issuing lodging house licenses. And Mr. Galvin correctly stated, and I actually highlighted that language for you in the copy of the decision I appended, that the selectmen do not make a land use determination in issuing a lodging house license, that they're making a decision, I don't have it in front of me instantly, but basically, is there adequate supervision? Is the facility safe?
Is it safe and suitable?
Because it's an interesting case just for the lawyers, because it goes through the whole history of the lodging house statute dating back to post-World War I. So it just sort of makes for interesting reading historically. So that was the only purpose of saying that there's some good language in that case that basically says, and I'm not suggesting the Milton Selectmen would do this, but you cannot use this other statute to, through the back door, was their words, take away the land use protections that religious and nonprofit educational institutions have. That was the only reason I cited that case. But otherwise, I think I appreciate the board's questions and just appreciate your due consideration of this matter.
Great.
Thank you.
Thank you very much. So we're going to close the evidence portion of the hearing, and we're obliged to consider this hearing in open session and to decide this issue. I think we're going to do it here and now. Let me just start out with a couple of preliminaries, but I don't mean them in the sense that they're not important. I really want to thank Mr. Galvin and Mr. Fishman for, I think both of them made outstanding presentations this evening. I think they were extraordinary, very experienced lawyers. You can tell they worked hard. Their written submissions are terrific. And they really, I thought, both did a wonderful job trying to support the positions of their respective clients, and they did it, in my view, in a very fair and honorable and collegial way, despite the fact that they dramatically differ as to their interpretation of the law. And that's always a wonderful thing. My experience from practicing law is that if you're dealing with great lawyers, they generally are very collegial. And they enjoy the issues, and they enjoy the intellectual jousting, but they're also a credit to their profession when they do that. And
Geez, I'm gonna come back here all the time.
maybe you've got some clients out there, but I sincerely mean
Is
that.
this on tape for my partners? I would like them to hear this.
But I sincerely mean that. And I'd also like to thank everyone for coming here tonight. It's 9:45. You've been away from your families, you've been away from sports and other activities, but we appreciate you coming tonight and listening. I'm always amazed, in a sense, but I shouldn't be, that even on complicated, controversial matters, whether it's dealing with Curry College, and we don't have too many controversy with Curry College, but Milton Hospital or some of the other nurseries amongst town, the neighbors who appear are all very well motivated. They're good-spirited. They don't engage in mean-spirited comments, and it's really a credit to the town. In some towns, frankly, people don't act that way. So I'm always thrilled with when people come and they participate and they understand the process, and whether they like our decisions or not. That's what the lawyers are for. If Galvin and his client don't like our decision, they have appellate remedies which they can exercise. So with all of that, and I'd like to also personally thank Mr. Prondak. He's been our building inspector for a long time. Sometimes we agree with Mr. Prondak. I think most of the time we do. Sometimes we don't, and we do reverse him. But Mr. Prondak has always been enormously collegial. And he's here today on his day off, and I'm sure he's not receiving extra compensation for spending his evening with us. And we thank him. Nobody, to the best of my knowledge, has ever criticized Mr. Prondak for not being collegial and cooperative. You can disagree with his decisions, just like you can disagree with our decisions, but we appreciate his hard work and his candor and his good services. So, thank you. With all of that having been said, I try not to speak first at these hearings, because running the hearings, I get so involved in the hearings. This is not the chairman's hearing, this is a hearing of the Board of Appeals. So I'd like to see if Mr. Frank O'Brien wants to be heard first.
Thank you, Mr. Chairman. This is a difficult one for me. And it is a difficult one for me because, as I mentioned earlier, in my professional life, I do lobbying and political work. And to me, this is a mixed political/legal question. And in my analysis, I believe that Mr. Galvin is correct on the politics. I don't like the fact that there is no currently available process to have an institution's feet held to the fire. I'm not at all, and let me emphasize that, I am not at all suggesting that Curry College needs to have its feet held to the fire, or that they have not acted in the utmost good faith. I'm not suggesting that at all. I'm saying, as a general matter, I think that land use planning, policy issues in general benefit from robust discussion, usually involving a disinterested party. Unfortunately, for Mr. Galvin, and fortunately for Mr. Fishman, I think Mr. Fishman's right on the law. I do agree with his reading of the Bible Speaks, his interpretation of the Dover Amendment, etc. I do agree that this is not a multifamily structure. I do agree that even if you do take the point of view that it is a multifamily structure and you get to the Dover Amendment analysis, I just don't see any other way around the handcuffs that the Dover Amendment puts on a local zoning board. In that regard, it reminds me a little bit of the telecommunication tower cases that we face all the time, with the handcuffs that are put on us by the federal government.
I hope you're not referring to today's First Circuit opinion,
I have not read the First Circuit opinion, so.
which reversed the board on the Green Mountain telecommunications pole. But why don't you continue with
Well,
that?
there you go. So, where does that leave me for the vote? Well, unfortunately, fortunately or unfortunately, trained as a lawyer like my colleagues, I have to go with the law. Well, I think my heart is with Mrs. Galvin in terms of the facts of the policy. I think the law is with you, sir. And I would vote to uphold the decision of the building commissioner.
Mr. Daber, please.
I also find this very, very difficult in the sense that I'm very sympathetic with the neighbors for their concerns about the construction process in a case where, as we've seen, basically the Dover Amendment, which is Mr. O'Brien rightly points out, handcuffs us in this case, requires the application essentially in certain cases that would be applicable to a single-family residence in a case involving a large dormitory and a multi-unit, if not a multi-family building. And I'm very sympathetic with the idea that that the neighbors would feel they don't have enough control or say about the matter. But I have also done a lot of research about this and given it a lot of thought, and I also want to congratulate both of the attorneys on great presentations, as the chairman indicated. They both did a wonderful job of laying out the issues and articulating them in a very clear and cogent fashion. But I also believe that it would be tantamount, if we found this, that the dormitory was subject to site plan approval, it would be tantamount to us amending the bylaw. I don't believe that the bylaw says that, and I think, unfortunately, I have to go with the law as argued by Attorney Fishman. And by the same token, I also agree that the Bible speaks is pretty much on point in this case, and would, even if it were applicable, technically, under the terms of the bylaw, we would be constrained from applying site plan approval to this project. So I would also be inclined to vote to uphold the decision of the building commission.
Well, my view of this is that my colleagues, I think, have framed the issues very, very well. I think that on the evidence here, I just could not find, as a matter of law, that this application is subject to the Section 8D of the zoning bylaw. And I think it's been parsed out fairly well. And everyone knows that when you go before the planning board, which has great skill in site plan review, they have tremendous control over a project. They can't deny a project, but there are a lot of very subjective factors that they apply in good faith in order to make the particular project not adversely affect or have detrimental effects on adjoining premises. And there's lots of bargaining back and forth, there's horse trading back and forth, and when all is said and done after 4 or 5 hearings, they generally have a pretty good site plan and everyone seems happy with it. But that's in a commercial context, and that's why the town meeting gave the planning board that type of authority, because they wanted that to happen. The legislature passed the Dover Amendment because they did not want that to happen. They didn't want to subject educational institutions to a lot of subjective conditions and tests and revisions of projects, because the educational use, just like agricultural uses, are considered protected uses to a large extent. That's the judgment of the general court. It's not the judgment of the Milton Town Meeting or the Board of Appeals. That's what the law is. And in my view, to subject Kerry College to the subjective requirements of the Milton zoning bylaw would be misapplying the law, number one, and it would be contrary to the decisions of the SJC, the Supreme Judicial Court, the Appeals Court, and maybe more importantly, it would be in opposition to the spirit of those decisions, because the Dover Amendment has particular items that can be considered, and here, Mr. Prondak told us they were considered, and they're objective findings. There's not a lot of subjectivity here. Parking may be an issue. I understand Mr. Galvin's argument on that, and I think Mr. Prondak did his very best and accomplished his objective to saying that that type of issue is not determined right out of the box. It's determined when you get to the shell stage of the project. So taking the law as we're obliged to find it, I think Mr. Prondak did what he was supposed to do. He made these findings. He didn't write lengthy reports. But the point is, I think nobody's left without a remedy in the sense that if Mr. Prondak allowed a 55-story building here or did something crazy, everyone would have a right to appeal. You have appellate remedies if you want to exercise them. I've heard no evidence at this hearing that Mr. Prondak was incorrect in finding that the bulk, the height, the yard size, the setbacks weren't in full compliance with the zoning bylaw. There's no evidence to the contrary. Maybe if Mr. Galvin and his clients or anybody else looks at the parking plan, maybe you can quarrel with that or quibble with that. But my guess is that type of questioning would be something that Mr. Prondak would listen to, and the college would listen to, and he'd probably come to some reasonable accommodation rather than spending tens of thousands of dollars about hustling over a parking plan. But I think that Mr. Prondak applied the law as written, and that the Bible speaks in these other cases indicate that not only does this process not subject Kerry College to variances or special permits, it doesn't subject them to the hassles of the standard type of site plan approval provided in our bylaw. Whether that's wise or not, I say take that to the legislature. Go see Senator Joyce or somebody. But that we have to apply the law as it's written, and I think my colleagues have properly explained that and analyzed that, and I think Mr. Fishman has made an argument that's right on all fours here, and so I think we're going to put this to a vote, but do you want to be heard?
Yeah, can I
Yeah,
just
of
say
course.
one other thing?
Sure.
And just to reiterate something that you said reminded me, that this is strictly with respect to the foundation permit. And as I understand it,
Right.
for any of the other permits, compliance has to be shown as well. So what you said about if the plan showed something that wasn't in accordance with the zoning bylaws as to any of the other permits, they'd be subject to,
To an appeal or a
Right,
questioning of Mr. Prondak. I think the essence of what Mr. Prondak was saying is a project that's a sophisticated building project is kind of an iterative project. It's not boom, it goes along in stages, and that the picture gets filled in as you go along in the construction process. And I think that comports with reality, and my guess is here that there are going to be no questions here. I'd also like to say this, the college, I think, and it doesn't weigh in my decision in one iota, because we're required to decide this case on the law. And the college has no obligation to negotiate any of these issues with neighbors, but I think the college has been very, very solicitous of the neighbors, and have tried to accommodate the neighbors. And I know as this process goes along, it's going to continue to do that, and we like that. If somebody thinks that the law is being violated, then they can take that up with Mr. Prondak. But I do think there were, and it doesn't weigh in my decision in the slightest, they don't have to do this. If they wanted to put that dome 45 feet off the lot line, if the bylaw says they could do it, then they can do it. But they didn't. They moved it back, and they made substantial considerations, and I thank them for that, just as a matter of municipal courtesy, and it's something that we've seen frequently, in my mind, from the college, so we thank you for that. So all those in favor of affirming Mr. Prondak's determinations here and effectively overruling or dismissing technically the appeal of Mr. Prondak's decisions, say aye. Aye.
Thank you.
Thank you very much for attending. It's been a great hearing. It's been a
Members of the board.
fascinating hearing. We've all learned a lot. I have at this hearing, and thanks for coming tonight, and have a pleasant evening, folks.
Thank you very much.